Lily, I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right to the right people. Subscribe before I keep going. The first thing I want to tell you about the morning the verdict came down is the silence after it. The room had been full of sound all week, chairs moving, papers turning, the low sound of someone crying that they were trying to hold inside. And then I spoke the sentence and the room stopped. Completely. The kind of stop that has nothing to do with quiet as an absence. This was quiet as a presence. Something had just entered the room, and nobody knew what to do with it yet. I want to come back to that moment, but first I want to tell you how we arrived there, because the silence at the end only means what it means if you know what it cost to get to it. She was 9 years old. She looked younger than 9 when she walked into my courtroom. Small, the way some children are small, not just in size, but in how they carry themselves, like they have already learned that taking up space is something they need to earn. She wore a blue cardigan that had been washed many times. The color had gone soft. She walked in with her mother, one step behind, and she sat down in the gallery and she folded her hands in her lap and she looked straight ahead. The thing I noticed that I have not forgotten, the thing that was small and human and true, was that at some point during the early proceedings, she reached into the pocket of that cardigan and took out a small smooth stone. She held it in her closed hand for the rest of the morning, never looked at it, just held it. I do not know where the stone came from, it is not in any record, but I watched her hold it, and I understood, in the plain way you understand something from a bench when you have sat behind one long enough, that someone had given it to her because she was going to need something to hold on to. The defendant's name was Dr. Raymond Costas, 53 years old. He had run a dental practice in a mid-sized suburban county for 19 years, framed degrees on the wall. I know this from the photographs submitted as exhibits. He was careful looking, the kind of person who folds a napkin before putting it in their lap. He sat at the defense table with his hands flat on the surface and his face still, and he answered questions in a measured voice. I watched where his eyes went when it was not his turn to speak. From the bench you notice what people do when they think no one is watching. His eyes went to the wall behind me most of the time, not to Lily, not to her mother. Once, during the second day, his eyes moved to the east window and stayed there for a moment, and something crossed his face. Not remorse, something more like tiredness, the kind that arrives when a person has been carrying a version of themselves they know is not exactly true. That was the one moment he appeared to me as a person rather than as a position. And I want to tell you why that made the whole thing worse rather than better. Because if it had been clean and cold and simple, it would have been easier to understand. But a tired man, a man who could look at a window with something that almost resembled feeling, that man chose this anyway. That is not a mitigating detail. That is a clarifying one. If something in what I have said so far has stayed in your chest, subscribe, because what I'm about to tell you next will stay longer. Subscribe now and then let me keep going. What happened was this. On the afternoon of October 14th, Lily's mother brought her to Dr. Costas's office at 4:45. She had made the appointment 3 days earlier, told the receptionist the tooth had been hurting for 2 weeks, and the pain had gotten worse. Her name was Patricia. She worked part-time at a laundry service. She did not have dental insurance. She had $60 in cash. She had seen a sliding scale payment option listed on the practice's website and had asked about it when she made the appointment and had been told it was something to discuss at the visit. They waited 32 minutes. Dr. Costas came out himself. He did not take Lily into an examination room. He spoke to Patricia in the lobby. He said, and this is a direct quote from Patricia's testimony confirmed by a second witness who was present, he said, "Without insurance, I cannot take on cases that require more than a cleaning. We have overhead. This is a business." He said it the way you say something you have said before. In the same words. enough times that the words have gone smooth. Lily's tooth had an abscess. She had been in pain for 2 weeks. She left that office in the same pain she arrived in. The abscess worsened over the following 9 days. On October 23rd, she was admitted to the emergency room with a facial infection that had spread from the original site. She spent 4 days in the hospital. She missed 12 days of school. The infection required a surgical procedure that could have been avoided if the tooth had been treated when her mother first brought her in. She was 9 years old. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. The case came to me as a civil complaint under the state's Consumer Protection Statute, running parallel to an administrative proceeding before the licensing board. I want to explain one thing about those 2 tracks in plain language, the way I would explain it to someone at a kitchen table. They asked different questions. The civil proceeding could produce damages, money. The administrative proceeding could restrict his license, what he was allowed to do. I sat in the civil proceeding, which meant I could tell him what his choice had cost in dollars. What I could not do from where I sat was tell him what it had cost in the way that actually mattered. That gap exists. I knew it then. I know it now. I am saying it once, and then I am continuing. The file that came across my desk was thin. That has stayed with me. For something that carried this much weight, the file was very thin. A complaint, a response, some exhibits, a set of medical records that described in precise clinical language what a 2-week abscess does to a 9-year-old's jaw. I sat with those records longer than was strictly necessary, not to build an argument, because I was trying to understand what it meant that words like localized necrosis and surgical debridement were sitting on paper, and that they referred to a child who had been in a waiting room with $60 and a hurt tooth and been sent home. There were 3 moments in that courtroom where the room went completely quiet, not the kind of quiet that happens between sentences, the kind that settles when something true has just entered the room and nobody knows what to do with it yet. I am going to tell you about all 3 of them. The first came on the second morning. Patricia was on the stand. She had been speaking clearly and steadily, the way someone speaks when they have told a story enough times in their own head that the telling of it has become a kind of discipline. She described making the appointment. She described waiting. She described standing in the lobby with Lily. Then she was asked what Lily had said on the drive home. She stopped. She looked down at the table in front of her, the way you look at something when you are trying to keep yourself steady. And then she said, "Mom, did he not want to help me because we do not have enough money?" The room stopped, completely. Not gradually. Stopped. The question had been in the room for 3 full seconds before anyone moved. The attorney at the plaintiff's table looked down at her notepad. Someone in the gallery exhaled. The silence lasted close to 10 seconds, which is a very long time for a room full of people trained to fill silence with procedure. The bailiff shifted his weight. The floor gave a small sound, and the proceedings continued. But something had changed. What I understood after that silence that I had not understood before, it was this. A 9-year-old child who was not in the room had just asked the only question that actually mattered, and no legal standard I had ever worked with was fully equipped to hold it. The evidence established 3 things clearly. 1. The sliding scale option on Dr. Costas's website had not been updated in 4 years and did not reflect any actual practice policy. 2. The standard of care required that a practitioner either treat a patient presenting with an abscess or provide a documented referral to someone who could. No referral was made. No documentation existed that Dr. Costas had assessed Lily's condition before declining to treat her. His own office records showed no examination had occurred that afternoon. He had spoken to Patricia in the lobby and sent them away without ever looking at Lily's tooth. 3. A former receptionist, a woman who had worked in the practice for 2 years, testified quietly, without drama, that when families came in without insurance and the doctor decided not to see them, staff were told to say the practice was fully booked. A pediatric dental specialist who had been practicing for 26 years said something I wrote down in my own handwriting. He said, "The tooth was treatable. At that stage, it was absolutely treatable. What was required was a decision." I kept that sentence. The second silence came on the third afternoon. Dr. Costas testified for 41 minutes. His attorney had prepared him well. He was composed. He used words like unfortunate and I understand the concern, and my practice has always operated within professional guidelines. He explained overhead. He explained the economics of a solo dental practice. His last answer was to a question about whether he had any regrets about October 14th. He said, I would handle the communication differently, but the decision itself, given the circumstances, was a business decision I had to make. When he finished, the room went quiet again. But this silence was nothing like the first one. The first silence had been the silence of something true arriving. This was the silence of something revealing itself, not arriving but settling, slowly, into complete visibility, like something partially obscured coming into full view. What I understood after this silence that I had not understood before was that there was nothing more to wait for. He had said it himself. A business decision, a 9-year-old child in pain, a business decision. I want to tell you about one other thing he said during his testimony. His attorney had asked him to speak about his relationship with his patients over the years, to establish who he was as a practitioner. He said, I have given a lot to this community. I have treated thousands of patients. I care about the people who come to me. He said it the way you say something you genuinely believe about yourself. I could see that he believed it. I wrote it down. I looked at it for a long time before I moved on to the next page. When I was very young, I could not have been older than 7, I had a toothache my family could not afford to treat right away. I sat in the kitchen one Tuesday evening while my mother pressed a cold cloth against my face because she did not know what else to do, and she needed to do something. I remember the cloth going warm against my skin. I remember the television in the next room. I remember the smell of something my grandmother was cooking and the way the ordinary things in the house kept being ordinary while I sat there with that pain. I never told anyone in that courtroom that memory. It does not belong in a file. But in the evenings when I was reviewing the case materials, it was in the room with me, sitting at the edge of everything I was reading, not explaining anything, just present. Subscribe before I go further. I have not told you what I ordered yet. I am about to. I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. I had made my decision carefully. I want you to know that. I had read every exhibit, every transcript, every piece of testimony. I had sat with the legal arguments and the human facts and the gap between them. I had made it knowing that careful and right are not always the same word, and believing in this case that they were. When I read the verdict aloud, the third silence arrived, and this one was different from both of the others. The first had been grief arriving, the second had been truth settling. This third silence had weight, like the room itself had become briefly heavier, like the air between all the people in it had thickened with the understanding that something permanent had just been spoken and could not be taken back. Patricia was still. Her hands were still over that folder. Her attorney put one hand briefly on her arm and she did not move. Dr. Costas looked down at the table. The gallery was absolutely still. The silence lasted about 8 seconds. Then someone in the back exhaled, and the weight shifted and the room became a room again. Then I addressed Dr. Costas directly. I am going to tell you what I said. I am ordering you to pay damages in the amount of $47,000, designated specifically for Lily's ongoing dental care and any medical follow-up resulting from the events of October 14th and the 9 days that followed. The number is not symbolic. It is the calculated cost of what was allowed to happen, plus the cost of what will now need to happen to address it. You had the means to prevent every dollar of it. You made a different choice. I am also ordering the suspension of your right to advertise sliding scale or reduced cost services on any platform or professional listing for a period of 3 years, unless and until you have demonstrated to the licensing board's satisfaction that those services are genuinely and consistently available. What you listed on that website was not a service, it was a suggestion that brought a woman and her daughter to your door. You will not be permitted to make that suggestion again until it is true. I am ordering 180 hours of service at a community dental clinic that serves uninsured patients. Not administrative hours, clinical hours. You will treat the patients who come through those doors with the same equipment and the same attention you bring to any patient in your private practice. You will do this because the skill you used as a reason to exclude people is the same skill that can reach them. I want you to know that. I want you to know it for 180 hours. I am ordering you to write and deliver a formal statement, in person, at a community health forum arranged in coordination with the county health department, before an audience that includes families who rely on community health services, acknowledging specifically what your practice did on October 14th and what its consequences were. Not a general statement about access to care, a specific one, with a specific date, a specific patient's age, and a specific outcome named plainly. And there is one more thing. You will provide Lily directly through the Restorative Damages Fund established by this order with full dental coverage through a licensed provider of her family's choosing for 5 years from the date of this order. Not a voucher, not a referral, coverage paid for because she came to you in pain and you sent her away. And the minimum that justice can require is that the specific need she walked into your office with is met and met in full. I told him this. I want to say it to you the same way I said it to him. You told a 9-year-old child through the choice you made in that lobby that her pain was not worth the cost of your overhead. She was old enough to understand what you communicated. She said so herself in a car to her mother on the way home. She asked if you did not want to help her because they did not have enough money. She was 9. She asked the right question, and she asked it because you gave her reason to. To your family, what happens in a courtroom is not the whole of a person, and they are yours to see in full. I do not ask them to carry what you chose. What your position required of you was not generosity. It was not charity. It was the minimum, a look, a referral, one sentence that told a woman and her daughter where to go next. That is what you withheld, not something rare or costly, the minimum. And the last thing I will say on this record is about Lily. She came to you holding something she needed. She left still holding it. She is the reason this record exists, and she is the reason every one of these orders exists, and she is who the last word of this proceeding belongs to. Thank you for staying with this. I mean it in the specific way you mean something when it costs you something to say. Subscribe if you have not yet. You already know why you are still here. After I stepped down, I stayed seated a moment while the room began to empty. Patricia stood up, gathered her folder, and her attorney said something quietly to her, and she nodded. Then she put one hand flat on the table for just a moment, like she was pressing down into something solid before she let go of it. Then she picked up her things and walked toward the door. As she reached it, she said something to her attorney that I was just close enough to hear. She said, "I have to go get her from school." I sat with that for a moment before I stood up. I looked at the room when it was nearly empty. Chairs at odd angles, tables still. The light coming through the east window in that long, pale shape that means the day is ending. The room looked the way rooms look when important things have happened in them and the things themselves are already becoming the past. It looked ordinary. It always looks ordinary in the end. That has never stopped being something I notice. Dr. Costas filed for appeal 7 weeks after the verdict. The appellate court upheld the civil award in full, modifying only the advertising suspension language to align with a state statute amended the previous term. The restorative coverage order was affirmed. The process took 9 months. When I heard the ruling, I did not feel triumph. I felt something quieter, something that belonged to the category of yes, that is what was right. I have been through enough of these to have stopped performing my responses to appellate decisions. On March 7th of the following year, I received a letter through the court's administrative office from Patricia, 2 paragraphs. The second one said that Lily had had her first dental visit under the coverage ordered by the court, that the dentist had been kind, that Lily had not been afraid. I read it twice, put it down, picked it up and read it one more time. I do not know whether what happened to Lily will happen less because of what that courtroom produced. I have been thinking about that for over 2 years, and I still do not know. What I do know is that grief and clarity are not opposites. If you sit with the grief long enough and honestly enough, it tends to produce a clarity that nothing else produces. Not comfort, not resolution. Clarity. The kind where you know exactly what happened and exactly what it meant and exactly what you could and could not do about it, and you can hold all three of those things at once without flinching. To anyone who has ever been sent away from a door they came to in good faith, with something real that needed tending, I saw that in Lily's mother. I have seen it before. The feeling does not have a simple name because it is not a simple thing. It is the feeling of having done everything right, having shown up, having asked, and discovering that showing up was not enough. If you know that feeling, I want you to know it was seen clearly in that room. To anyone who has ever stood where Dr. Costas stood, behind a policy or a desk, and placed cost above the person asking, I am not speaking with contempt. I am asking you one honest question. When it is quiet and no one is watching, and you are not defending the decision, do you know what it actually cost? Not in liability, in the weight of it. That question is not a trap. It is a door. It is the beginning of the only clarity that matters. There are other people I want to speak for, other cases where someone needed a voice in that room and received procedure instead. Subscribe and I will tell you those stories when I am ready. This was the first one I was ready for. Lily. To anyone who has ever made Dr. Hale's calculation, not necessarily in medicine, not necessarily with those stakes, but in any situation where you ran a number before you ran to help.